Welcome to this video on the collision course. We will explore how a landmark Supreme Court ruling and a global oil crisis have fundamentally reshaped New Zealand's energy future. New Zealand faces a conflict between short-term survival and long-term liability. The Supreme Court ruling in December 2025 created the most restrictive, climate-friendly fossil fuel precedent. Months later, a global oil crisis led to a crippling fossil fuel shortage in petrol, hitting $3 per liter. The case is Climate Clinic Aotearoa versus Minister of Energy and Resources. The challengers were grassroots law students, and the target was the Crown Minerals Act 1991. The core question was whether the Crown could issue new petroleum exploration permits without considering the climate impacts of the fossil fuels. The benefit timeline shows the evolution of the, quote, "for the benefit of New Zealand" clause. The 2025 Supreme Court precedent mandated that, quote, benefit must now include an assessment of planetary health and climate impact, going beyond the earlier promotional era and the 2018 ban. The Supreme Court intervened based on the CREEDNZ administrative law principle. The court ruled that failing to consider climate change is a failure to act within the law, because fossil fuel extraction inherently causes greenhouse gas emissions, making climate change, quote, so obviously material. The ruling installed a mandatory climate check at the block offer stage, for Section 24, requiring the minister to assess global emissions impact. While Section 25, the permit grant, focuses on operational capability, the climate assessment is a high barrier to entry at the initial stage. The Supreme Court precedent expanded the treaty radius. The new standard of active protection means the Crown must consider systemic climate impacts on Maori treaty interests nationwide. Global warming is now a direct treaty issue. The 2026 reality check exposed a strategic vulnerability. With the closure of Marsden Point, New Zealand imports 100% of its refined fuel. The global shock of the Strait of Hormuz closing, coupled with price exposure of crude potentially reaching $150 a barrel, left the nation entirely exposed. The Fuel Security Dashboard for April 2026 showed low reserves, 33.3 days of petrol and 28.3 days of diesel cover. The government initiated an emergency response, triggering a national fuel response and relaxing trucking weight limits to conserve diesel supplies. The dual crisis led to a public divide. Industry critics view the ruling as an, quote, usurpation argument, leading to economic ruin. Environmentalists argue that the crisis validates the law, emphasizing that electrification is the only true security. The policy collision created a stalemate. The executive goal to reverse the 2018 ban and open new areas for oil is legally perilous due to the judicial guardrail. The ruling requires any new block offer to prove a net benefit to planetary health. On the continental shelf conflict map, the petroleum industry and the renewables sector are competing for the same territory. The Supreme Court's mandate, prioritizing, quote, benefit of New Zealand with climate assessment, legally gives the right-of-way to renewables. The legal shift is a paradigm change in evaluative governance. Before 2025, the core purpose was promotional, climate change was irrelevant, and consultation was localized. Now the purpose is evaluative, climate is a mandatory consideration, and the Treaty of Waitangi requires systemic evaluation of climate impacts. In synthesis, the 2026 energy crisis validates the Supreme Court ruling. Fossil fuels are a geopolitical liability due to foreign reliance and a domestic environmental liability. The law and the market now point in the same direction: aggressive transition. New Zealand has entered a new era of evaluative governance. The benefit of the nation is no longer measured in barrels extracted, but in carbon budgets respected and planetary health preserved. The era of unconditional fossil fuel expansion is over.